In the news lately has been discussions about certain Democrats in Congress want to ban private militias or private paramilitary organizations or whatever this is. Well, this is really an absurd concept and in my view simply a PR stunt. We're going to break down some of the constitutional questions, and by the way, some of these discussions have popped up in the past in the 1960s, and we're going to discuss a little bit here and right now. A lot more we can talk about later if you guys are interested, but for now I'm just going to hit the highlights as to why these notions of banning private militias and banning private paramilitary organizations or whatever these political propaganda terms the Democrats have come up with, why all of this is simply absurd and yes indeed unconstitutional under the Bill of Rights. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. Okay, folks, so here's the deal. I'm in a little bit of a rush today. I got a bunch of Fox News stuff I got to do. Got some appearances coming up. It's going to be a really busy time. I can tell already where this is going with 2024, the presidential election. Going to be a lot of Fox News and other media time, so make sure you check me out on all those various channels that I will be on outside of YouTube here. All right, but anyway, we want to talk today about these attempts by Democrats, certain Democrats, to try to ban private paramilitary organizations, which is a political propaganda term for militias or people coming together to exercise their Second Amendment rights. That's as best I can tell. So in a nutshell, let me give you a little discussion about it. Then we're going to break it down why this is just simply stupid and a PR ploy by the left. To begin with, so for example, you have this proposal by Congressman Jeremy Raskin and Senator Markey, I think he's out of Massachusetts, yes he is, to ban so-called private military or whatever you want to call these things. Specifically, this is the announcement they made, and this is what they say. Following the anniversary of the January 6th attack on the U.S. Capitol, Congressman Jamie Raskin and Senator Edward Markey introduced the Preventing Private Paramilitary Activity Act, legislation that would create a federal prohibition on paramilitary groups through civil and criminal enforcement. All right, so that's what the idea is, but let's cut to the chase. This is simply an absurd notion, because here's the bottom line. Whatever you can do individually under the Constitution, you can do as a collective group. Just think about this, for example. If I can pray to God by myself, I can pray to God as part of a group in a church, in a synagogue, for example. Okay? If I want to write a letter to my congressman or petition the government to redress a problem, I can do it by myself. But I can also do it as part of a group. My neighbors can get together with me and we can write a letter to a congressman, for example. Likewise, in addition to being able to worship together or exercise free speech, the right to petition the government, we can also exercise free speech. I can go out to the park and hold up a sign that says, I don't like Joe Biden. And other people can join me with signs that say, I don't like Joe Biden. Again, whatever I can do individually, constitutionally, I can do as part of a group. Collective activity, collective use of or exercise of constitutional rights is very basic American life. We know that. Beyond that, as a practical matter, I don't see how there's any real way to distinguish between, group training and private military organizations. It just seems to me rather silly that they're even trying to have this debate. And I think it's unconstitutional under certain precedent we'll get to in a second. But nevertheless, the bottom line is, if you think about it, so at what point does a group become like an army or a military or militia? What exactly does it mean? So if you and I have a book group where we talk about American history and the Civil War, or we talk about the Navy SEALs, and we're in a book group and we're talking about a lot of different things, well, is that somehow a paramilitary group because we're talking about militia history or militia or military history or whatever that is? Like, what does that mean if we're in a book group? What if we're in a paintball team? What if we all go out there and talk about military tactics so we can win paintball tournaments, which are very popular? Or what if we're engaged in, gun competitions, 3-gun competitions, or whatever you want to say? Are we now part of a militia because we're working together to improve our training to win certain legal contests under, like, say, the civilian marksmanship program or whatever? And of course, there's other instances like reenactors. For example, the New England Patriots have something called the Minutemen. I think they're called the end zone militia, right? And every time the New England Patriots score a point, a touchdown or a field goal, the Minutemen, the Patriots militia, the end zone militia, they fire rounds right there in an NFL stadium, right? As an ode to Lexington, Concord, and the Minutemen and all of that. So the idea that you can somehow ban these collective activities to exercise your right to keep and bear arms is rather silly. We also know that in the modern times, there's no shortage of collective group defenses. The Rooftop Koreans is just a great example of this. People coming together, each individual exercising the right to keep and bear arms, but they're doing it together, no different than if you're in a church praying train, or again, you're in a protest protesting something as a group. Perfectly legal, perfectly constitutional. Now, what the anti-gunners may talk about is they like to talk about this Presser case, Presser versus Illinois case from the 19th century. It actually really doesn't do that much for them, because if you look at the Presser case, all it really says is there was a discussion about whether you could come together as a body to train and parade. And the issue there was really one of permitting. If you look at the case carefully, it was a situation where they had to get a permit, and the debate was whether or not they had to get a permit. So I don't even know if Presser is good law anymore, but even if it is good law, it's not necessarily a big deal when it comes to our Second Amendment rights. Keep in mind that the anti-gun movement in the Heller case before the U.S. Supreme Court in 2008 literally relied on the Presser case to try to say that we did not have an individual right to keep and bear arms. And the U.S. Supreme Court in Heller in 2008 literally distinguished Presser and said, well, this doesn't speak to the individual right to keep and bear arms. And they basically just dismissed it as not particularly relevant to anything. So to the extent the anti-gunners want to use the 19th century Presser precedent, A, it's not helpful for them. And B, is the Supreme Court basically has already rejected it as particularly important to anything. The other thing to keep in mind, and this is more of a modern historical context, there were attempts in the 1960s during whatever you want to call the 1960s, where you had sort of radical movements. The government wasn't happy with certain groups and whatnot. And there were attempts to try to ban some of these activities. I think a famous one is a federal criminal law, 18 U.S.C. 231, which deals with civil disorders and whatnot. And what you're going to find interesting is some of the language from that 18 U.S.C. 231. Listen. So the critical thing, and I'll put a link to it down below, but I don't think you have to read it. You can check it out if you want. But the critical thing about 18 U.S.C. section 231 dealing with civil disorders is the first clause. It says, whoever teaches or demonstrates to any other person the use, application, or making of any firearm or explosive or incendiary device or technique capable of causing injury or death to persons, on and on and on. So the point is, there was already discussions in the 1960s and laws enacted trying to say that if the radical groups in the 1960s, the communists, whatever they were going against in the 1960s, there was already discussion of this kind of a concept of preventing people from training and learning how to protect themselves. And the reality is, I think there were courts back in the 1960s, I can do some research if you guys care enough, basically saying that a lot of this stuff potentially violated First Amendment rights and the right to freedom of association, to come together and interact with other people with like mind to learn about certain things. So the bottom line is, some of these discussions were actually discussed, some of these issues were discussed in the 1960s, and at the end of the day, I don't think they really went very far. There was a law enacted, but there's a lot of questions as to whether or not these attempts to stop subversive training groups somehow is constitutional. And again, that's what we're really dealing with, is 1960 era laws to stop subversive training groups using laws that are likely in violation of the First Amendment and that they're rarely enforced, probably because they are viewed as unconstitutional. Congressman Raskin and Senator Markey make the following observations. They write, quote, there are currently no federal laws that address paramilitary activity or protect millions of Americans whose rights are threatened by this type of violent anti-democratic intimidation. Although all 50 states prohibit private paramilitary conduct, these laws are far too often outdated, under-enforced, or ignored. Well, you know why they're ignored or under-enforced? It's probably because they're unconstitutional. Okay, I'm familiar with this Georgetown thing they referenced. I can take another look at it again. But the bottom line is, you cannot prevent people from exercising constitutional rights together that they could do individually. So if I have a right to train with my gun, which is the Ezell case out of the Seventh Circuit, if I have the right to practice, if I have the right to shoot my gun for target practice, for hunting, to get ready for self-defense, to get trained in all of these kinds of things, well, I can do that by myself or with others. It seems to me, again, there's not going to be a constitutional basis for justifying any of these laws, and I don't see how they could be upheld. And again, we already know there's laws on the books that say if people come together as a group to conspire to actually commit a violent crime, like a drug gang that comes together where everyone comes together, sits down in a room and says, we're going to engage in a terrorist act of like 9/11, or we're going to come together and we're going to engage in the drug trafficking business and we're going to sell fentanyl or cocaine or whatever it is. There's already laws on the book that prevent people from coming together and conspiring to engage in violent crimes. That's already illegal and has been forever. So what we're really talking about here in terms of Congressman Raskin and Senator Markey and some of these other Democrats is they really just want to infringe upon your Second Amendment rights because they think you're a peasant. They think you're a peon and a subject. They simply don't think that you have a right to keep and bear arms, and they want you disarmed because they don't trust you with guns, and they want to have a monopoly on force. It's consistent with what other people who want to do bad things to people want. They don't want anyone else to have the weapons. That is the case going throughout history. You know, if you disarm your political opponents, it's a lot easier to bully them around. And I think that's what this is really about. This is not about public safety or public security or anything like this. Again, these kind of games were played in the 1960s in Congress and federal government and largely were viewed as unconstitutional then. And they certainly would be viewed as unconstitutional in the courts today in the 21st century would be my best take right now. Okay, so there you have it. A few discussions on these quote unquote paramilitary laws, these militia laws, whatever euphemism or political propaganda term the anti-gunners want to come up with. But this is really just another attack on the Second Amendment, nothing more or nothing less. All right, folks, so there you have it. We'll talk to you soon here at the Four Boxes Diner. Make sure you subscribe and resubscribe. Don't get knocked off the list here. And don't forget to follow me on X at Four Boxes Diner. And we will see you again soon here enough at the Four Boxes Diner.
Orders up. Table 2A.